Assalamu alaikum. I welcome you to the series of lectures on international law. In this area of international law, we have been studying so far about the theory of international law, the issues in international law, important case studies. We have looked into some very important issues like terrorism, law of the sea, law of armed conflict, aggression, Geneva Conventions, and several other issues. And these issues highlight the growing significance of the area of international law, because this area is continuously growing. It is growing through massive legislation being done at international level. And this area also highlights the need to develop capacity to understand all these issues, because without that capacity and without that understanding, no country, no state can advance its national interests properly. Now, on one hand, international law is important because it creates rights, it creates obligations, it regulates conduct amongst the states. On the other hand, it is important because it also highlights that the states can take various advantages based on their clearer understanding of international law. If they understand how international law works, if they understand how the legal instruments provide jurisdiction to various entities, if they understand how this jurisdiction can be utilized proactively in their interest, they can certainly make very constructive political moves and thus take full advantage of international law. But most of the time, the developing world in particular does not have the capacity to understand the legal language of international politics. And because of this lack of understanding, the state interests suffer. And because of that suffering, the conditions of these states do not improve. We had discussed and we have touched on various issues of international law in our previous topics. Each of this topic highlights the significance which this discipline has associated with it. And each of these topics points out to us the importance that is attached to the development of these disciplines and how these disciplines are growing on a day-to-day basis. And people often ask me that, well, you have the treaties, we have the laws, where are they implemented? Where are they located? Is there an entity, is there a place beyond the states where one can find international law at work? Is there an instrument? Is there a venue? Are there any forums where international law is seen as into operation? Well, in a traditional sense, obviously the entire territory of a state is occupied. The entire territory of the state has been divided in various, provinces, and the entire territory of the planet has been divided into states. So there is no extra territory left on which you can position a multilateral, beyond the state venue which can address issues of the states and statecraft. But yes, there is a virtual presence of an international bodies beyond the state which have the effect of influencing the affairs of the state in a big way. These virtual bodies, which are created through international treaties, have developed themselves into a virtual reality. And through this virtual reality, they create influences, they bring changes, they set up new directions, new goals for the future, and thus they have profound effect on the states and their functioning directly. This virtual presence of these international institutions cannot be undermined. Obviously, they are placed in some capital or some country. Several of these organizations are set up in Geneva, for example. Several of these organizations are found in Vienna. In Vienna, if you see on television, the Vienna International Center, a huge building in which IAEA head offices, other UN bodies are also there. So they are present within a state territory, but they have legal independence and they have a headquarters agreement with that state which permits those organizations to operate independently. Similarly, in New York, you have various UN bodies. They are present on the territory of US, but they have legal independence and they have legal detachment from the US laws. And this detachment creates a unique legal creatures. So this virtual reality of international organizations is worth taking notice of. These are the venues of development of international law. These are the venues where international law is growing based on the mandates of these societies. And this is our topic today. The selective UN bodies. A look at the selective UN bodies and their functioning. So we will look at this topic in the context of these bodies, and we will see how these bodies operate. These international bodies have unique positioning. They are either the product of multilateral treaties, or they are a product of bilateral treaties, or they are a product of resolution of an international organizations. So it really depends that where are they coming from, but they are present. And as I indicated to you, in the Vienna International Center, in Geneva, if you go, you will find various international organizations, ICRC, WTO, WIPO. If you go to Hague, you find judicial venues such as ICC, International Court of Justice. All these organizations have virtual presence. They are delinked from the laws of that state, and they have a relationship which is spelled out through a specialized agreement with the host state, and that is called generally a headquarters agreement, which defines the physical relationship between the state where they are host and the organization which is created by a multilateral treaty. So these people who work, or the officials who work in these organizations, work as effectively international civil servants. And there are a number of them. These international civil servants are found in all these international organizations, and their number runs into thousands. So these international civil servants, these international organizations are more powerful, and as they may appear on the first look, their range, their scope, their reach is far greater than their own brick and mortar that symbolizes their existence. So the bodies which work, international organizations that work within the UN system or outside it, are organizations that are looking after various areas. They are specialized organizations. Now, all the organizations do not work under the umbrella of United Nations. Some of the organizations could be completely independent in terms of their mandate. They could be developed on the basis of regional treaties. So if you have SAARC, South Asian Organization, then a regional cooperation organization, then that is not created under the UN system. It is created by a few countries in South Asia who have entered into a multilateral treaty, and through that treaty they have created an organization called SAARC, and they have defined the mandate of SAARC through a SAARC charter. The SAARC charter governs the functioning of SAARC, and it spells out what will be the objective functions, powers of the SAARC, what will be the functions of its officials, what will be the mandate of the organization, and how this organization will function, etc., etc. So whenever you look at these organizations, you primarily look at the treaties which establish them. And all these organizations are established through multilateral treaties. Now, having said that, in general about all international organizations, we will come towards the bodies related to United Nations. I have used the word related. What do I mean by that? Bodies established by UN or bodies linked with United Nations. What do I mean by that as well? Are these bodies created under the UN Charter? So how are they linked as UN affiliate bodies, and what does that mean in a legal sense? After all, under the UN Charter, we have only 6 organs. United Nations is nothing beyond those organs. So those organs put together create United Nations. So when we say United Nations, we mean the organs, these 6 organs that are found in the treaty called the UN Charter. So what are the other organizations? I will explain this to you through a chart or a diagram that I will draw on the board, which will give you a more clear idea of the nature of the work that these organizations do and they function within that framework. In this chart, we will also make an effort to identify that how these functions are carried out by these organizations. Now, for example, this is United Nations, and UN is a creation of UN Charter. So what do we have? We have 6 bodies which are the constituent instruments of the Charter. UN Charter, remember, is a multilateral treaty. It creates UN, and what does UN means? UNSC, UN Security Council, UNGA, United Nations General Assembly, then is Trusteeship Council, then is ECOSOC, then is the Secretariat, and then is the ICJ, International Court of Justice. Now these are the organs of United Nations, and United Nations is nothing beyond these organs. They are Security Council, General Assembly, Trusteeship Council, Economic and Social Council, the Secretariat of the UN, and the International Court of Justice. When we say UN affiliate bodies, what do we mean by that? We mean bodies which were established not under the Charter directly, or they were not mentioned in the Charter, but they are linked with the concept and the preamble of the UN Charter. So let me give you an example of only a few organizations. For example, we have UNICEF, there is WHO, there is ILO, there is IAEA, and etc., etc. Now, these organizations were set up outside the UN system, but they were fulfilling the mandate of the UN system. Because if you remember, in one of my lectures I had mentioned that the Charter was focused on a broad framework that you must ensure peace, not merely to avoid war. The League of Nations was set up in order to avoid war, to restrict any country going into war. So the success was measured by the fact that countries have not gone to war. So when Second World War happened, the League of Nations found itself lacking of a rationale. But the UN came, and it was based on the experience. And even if you don't have war, that does not guarantee a situation of peace. To ensure peace, you required several other issues. You need to make sure that the health of the people in the state is all right. There is no serious outbreak of a disease. If there is one, there will not be any peace in that country. You need to make sure that laborers in a country are given their rights. If they are deprived, if they are oppressed, they will retaliate, and the situation of peace will not be properly handled. So all these issues were considered worth of attention in a serious manner. And that attention translated into creating specific bodies. And these bodies, the mandate was to ensure peace in one way or the other. So you had UNICEF, which had a focus primarily on children's welfare. You had WHO, which had a focus primarily on the health of the people in a given state. Immunization, टीकों का जो आप सुनते हैं सारा प्रोग्राम, और वो टीका लगवाइए, और पोलियो का जो मामलात हैं, सब चीज़ें किस हवाले से हैं? ये WHO का, ताकि लोगों की हेल्थ जो है वो इंश्योर की जाए. इंटरनेशनल लेबर ऑर्गेनाइजेशन, लेबरर्स के लिए. IAEA, ऐसे मैटर्स जो न्यूक्लियर से रिलेटेड रखते हैं उनके इश्यूज पर. अब चूंकि इस तरह की ऑर्गेनाइजेशंस जो हैं, they were actually providing support to the UN's original mandate. Therefore, it was decided to associate with them as affiliates, कि इनको affiliation दे दी जाए. So they became affiliated with the UN. And they are thus called the affiliate bodies of the UN system. Now the other important thing is, اس کو آپ یوں سمجھ لیں جس طرح سے کہ پنجاب یونیورسٹی جو ہے وہ اپنے ساتھ کچھ پرائیویٹ کالجز کو افیلیٹ کر لے. مثلا پنجاب یونیورسٹی کا ایک لا کالج ہے, کئی پرائیویٹ لا کالجز شہروں میں کھلے ہوئے ہیں, لیکن پڑھاتے وہ خود ہیں, انڈیپینڈنٹ ہیں, ان کے اپنی جگہ ہیں, ان کی اپنی مختلف ان کی پریمسز ہیں, پرنسپل مینجمنٹ سب انڈیپینڈنٹ ہیں. مگر جب وہ داخلے کے لیے فارم جاتے ہیں اور امتحان دینا ہوتا ہے تو پھر وہ امتحان پنجاب یونیورسٹی لیتی ہے اور ان کو افیلیشن دیتی ہے, یہ طے کرنے کے بعد, یہ اسیس کرنے کے بعد کہ یہ پرائیویٹ کالجز جو ہیں یونیورسٹی کا جو لارجر پرپز ہے آف اسپریڈنگ ایجوکیشن اس کو پراپرلی ادا کر رہے ہیں کہ نہیں. تو یونیورسٹی اپنی کمیٹی بھیجتی ہے, یہ اسیس کرتی ہے کہ یہاں پر پڑھائی ٹھیک ہو رہی ہے, اساتذہ ٹھیک ہیں, جو پروڈکٹ نکل رہا ہے وہ ٹھیک ہے, بیسک سہولیات ہیں تو نہیں ہیں. تو پھر جب یونیورسٹی میں پہنچتی ہے تو پھر ان کو وہ افیلیشن دے دیتی ہے. یہی ایک کروڈ سی ایگزامپل ہے افیلیشن آف دیز آرگنائزیشن ود یونائٹڈ نیشنز, کہ وہ ادارے جو عالمی سطح پر UN سسٹم سے باہر وجود میں آئے ہیں ان کو اقوام متحدہ نے افیلیشن کا درجہ دے دیا ود اقوام متحدہ, جب اقوام متحدہ اس نتیجے پہ پہنچا کہ یہ ادارے اسی کے لارجر مقاصد کو آگے بڑھانے میں مد و معاون ثابت ہو رہے ہیں. سو دیٹ از ہاؤ یو ریفر ٹو دیم ایز UN bodies اور UN affiliate bodies, but they are different from the UN organs. ان کو آپ آرگن کہیں گے, یہ آرگنز ہیں. یہ آرگنز اس لیے ہیں کیونکہ ان کا مینشن UN چارٹر میں ہے, یونائٹڈ نیشنز کے چارٹر کے اندر ان کا ذکر ہے. ان کا ذکر UN چارٹر کے اندر نہیں ہے, نہ ہی ان کو بناتے وقت UN چارٹر کی امینڈمنٹ کی گئی. تو یہ UN چارٹر سے باہر ہے, یہ UN چارٹر کا حصہ ہیں, یا یوں بھی کہا جا سکتا ہے کہ دے آر دا یونائٹڈ نیشنز. اقوام متحدہ ان سے بالا کوئی اور چیز نہیں ہے. Now having said that, one needs to look at some other bodies or functions of the UN that one finds in this context. اقوام متحدہ کے بے شمار ایسی کمیٹیز ہیں, بے شمار ایسے ذیلی ادارے ہیں جو اس چارٹر سے اپنا مینڈیٹ ڈرا کرتے ہیں. فار ایگزامپل UN سیکیورٹی کاؤنسل کے نیچے مختلف کمیٹیز بنائی جا سکتی ہیں اور مختلف ادارے وجود میں لائے جا سکتے ہیں. تو یہ ادارے جو ہیں یہ اس مینڈیٹ کے نیچے بنائے جائیں گے جو UN چارٹر میں دیا گیا ہے. تو اگر UN کی سیکیورٹی کاؤنسل ایک کمیٹی بناتی ہے جو ٹیررزم سے متعلق ہے تو وہ اپنا مینڈیٹ ڈرا کر رہی ہے چارٹر کے نیچے. اسی طرح UN سیکیورٹی کاؤنسل اگر کوئی خاص ادارہ بناتی ہے کسی مخصوص ٹیریٹری کی ڈسپیوٹ کے لیے, جیسے کہ سیکیورٹی کاؤنسل نے UNCIP بنایا, یونائٹڈ نیشنز کمیشن فار انڈیا اینڈ پاکستان. اگین وہ کمیشن بنا تو UN سیکیورٹی کاؤنسل کے نیچے اور اس کا مینڈیٹ UN چارٹر سے ہی ڈرا ہو رہا تھا, جو ہم تھوڑا سا تفصیل میں جا کر آگے سے اس چارٹر کو جب ایگزامن کریں گے تو دیکھیں گے. اسی طرح UN کی جنرل اسمبلی ہے. اب اقوام متحدہ کی جنرل اسمبلی جو ہے اس میں تمام کے تمام ممالک جو ہیں وہ اس کے ممبر ہیں, 194 ممالک جو ہیں اس کے ممبر ہیں. جب یہ ممالک اس کے ممبر ہیں تو یہ بیک وقت کمیٹی یا UN جنرل اسمبلی ہر وقت ہر کام ہر ایشو کو نہیں بات کر سکتی, ڈیبیٹ کر سکتی. ایک بہت بڑا سا ہال جس کو آپ تصویروں میں یا ٹیلی ویژن پہ دیکھتے ہیں جس میں مندوبین بیٹھے ہوتے ہیں, وہاں پر یہ پاسبل نہیں ہوتا کہ آپ ہر ایشو ہر ایجنڈے کو کنکلوڈ کر سکیں. تو اس کے لیے پھر UN جنرل اسمبلی بھی اسپیشلائزڈ کمیٹیز بناتی ہے اور مختلف کمیٹیز مختلف کام کر رہی ہوتی ہیں جو UN جنرل اسمبلی ان کو کام تقویض کرتی ہے, ان کو ڈیلیگیٹ کرتی ہے, اور مختلف کمیٹیز یہ کام کر کے پھر UN جنرل اسمبلی کو یہ کام واپس لا کر دیتی ہیں. اسی طرح ٹرسٹی شپ کاؤنسل اب متروک ہو چکی ہے, مگر اس کا اس وقت مینڈیٹ یہ تھا کہ اس نے جو ٹرسٹ ٹیریٹریز ہیں ان کی ایڈمنسٹریشن کو گریجولی ہینڈل کرنا ہے. اسی طرح اکنامک اینڈ سوشل کاؤنسل, اکنامک اینڈ سوشل کاؤنسل جو ہے اس کا مینڈیٹ بہت واضح اور بہت بڑا ہے, اور اس کا تمام سوشل اور اکنامک ایشوز کا مینڈیٹ ہے اکنامک اینڈ سوشل کاؤنسل کا. اگین اس کے نیچے کمیٹیز اور سب کمیٹیز جو ہیں وہ اسٹیبلش ہوتی ہیں جو مختلف اکنامک ایشوز کو مختلف سوشل ایشوز پر یا ڈائریکشن یا مشن اسٹیٹمنٹ یا پالیسیز کو واضح کرتی رہتی ہیں. جو سیکریٹریٹ ہے یو این کا، اس کے جو ہیڈ ہیں وہ سیکرٹری جنرل آف یونائٹڈ نیشنز ہیں. سیکریٹریٹ بھی ایک بہت فل فلیج سیکریٹریٹ ہے، ایک فل فلیج آفس ہے جہاں لوگ پرماننٹلی امپلائے ہو کر کام کرتے ہیں، اور ان کا ہیڈ سیکرٹری جنرل ہے. سیکرٹری جنرل کو کچھ اختیارات دیے گئے ہیں ود ان دا فریم ورک آف دا چارٹر. ان اختیارات کے اندر رہ کر سیکرٹری جنرل جو ہے وہ کچھ نہ کچھ کام کرتے رہتے ہیں. سیکرٹری جنرل کو عموماً مینڈیٹ دیا جاتا ہے بائی یو این سیکورٹی کاؤنسل ٹو ریمین سیزڈ آف دا میٹر ٹو رپورٹ بیک ٹو دا یو این سیکورٹی کاؤنسل سرٹن میٹرز، اور یہی یو این جی اے بھی کرتا ہے. تو بے شمار ریزولوشنز جو یو این جنرل اسمبلی پاس کرتی ہے اور یو این سیکورٹی کاؤنسل پاس کرتی ہے، اس میں سیکرٹری جنرل کے آفس کو مخصوص ڈائریکشن دی جاتی ہیں، اور پھر سیکرٹری جنرل سے کہا جاتا ہے کہ آپ ان معاملات پر رپورٹ بیک کریں، جو کہ یو این سیکرٹری جنرل کا آفس پھر وہ رپورٹنگ میکینزم میں انوالو رہتا ہے. انٹرنیشنل کورٹ آف جسٹس جو ہے وہ جوڈیشل فورم ہے یونائٹڈ نیشنز چارٹر کے نیچے. اگین اس کے نیچے مینڈیٹ نہیں ہے کہ آپ سب کمیٹیز وغیرہ بنائیں اور ڈیٹیلز میں جائیں. تو اگر آپ نے ایڈ ہاک جوڈیشل فورم بھی بنانا ہے تو اس کا اختیار آئی سی جے میں نہیں ہوتا. اس کے لیے آپ کو اگین یو این سیکورٹی کاؤنسل میں رجوع کرنا پڑتا ہے، اور یو این سیکورٹی کاؤنسل اپنی کسی ریزولوشن کے تحت ایک جوڈیشل فورم اسٹیبلش کرتی ہے، اور اس جوڈیشل فورم کا بجٹ، اس کی فنکشننگ، اس کے آفیشلز کا تعین اسی میں ہوتا ہے. تو بوسنیا اور روانڈا کے جو وار کرائمز ٹرائیبیونلز تھے، ان کے لیے جب ایک اسپیشلائزڈ ٹرائیبیونل اسٹیبلش کیا گیا تو وہ یو این سیکورٹی کاؤنسل نے اسٹیبلش کیا، نہ کہ انٹرنیشنل کورٹ آف جسٹس نے، بیکاز یہ مینڈیٹ یو این سیکورٹی کاؤنسل کا تھا ٹو کریٹ اے باڈی. آئی سی جے کے پاس یہ مینڈیٹ نہیں تھا. ان ادر ورڈز یہ سارے جو ادارے ہیں، اب آپ نے ان کو دیکھا کہ ان کی لیگل پوزیشننگ کو ہم کلیئر کر لیتے ہیں. وی ہیو اے یو این چارٹر، وی ہیو دی آرگنز آف دی یونائٹڈ نیشنز، and then we have the committees and subsidiary bodies which are created by these organs independently, and these subsidiary bodies or these committees or these organizations draw their legal mandate from these organs, and they are a part of the UN. And then there are bodies created outside the UN Charter, but they get affiliated with the United Nations based on their mandate, objective and purposes. So this is a three-tier positioning. And then of course there are set of international organizations that operate completely independently from affiliation with UN. ICC, for example, International Criminal Court, ICC, International Chamber of Commerce, for example, and several other bodies operate completely outside the United Nations, and they operate as international or multilateral organizations. And again, they are thousands in numbers. So the functioning of each organ or each organization has to be understood with reference to the governing treaty, governing text, governing resolution that it creates. This gives you hopefully some sort of a perspective on the UN Charter, its organs, its way of functioning, and how does it operate. I will now discuss briefly with you a broad framework of one or two of these bodies. How do they function, and what is the significance of these bodies? And we will also go through the provisions of the UN Charter in order to understand how an international organization is structured, what are the functions given to it in its charter, and how that charter or how that constituent instrument has to be understood in order to better appreciate that what is the function of that body, and also to rationalize expectation with reference to that. Sometimes لوگ بہت زیادہ توقعات وابستہ کر لیتے ہیں کسی عالمی ادارے سے، اور سمجھتے ہیں کہ یہی امرت دھارا ہے تمام تکالیف کا، اور یہی داد رسی کر سکتا ہے. مگر جب تک آپ اس ادارے کے اس قانون کو نہ دیکھ لیں جس قانون کے توسط سے وہ ادارہ وجود میں آیا، اس وقت تک آپ بالکل نہیں کہہ سکتے کہ اس کی کیا کیا اختیارات ہیں. سو اگر آپ یہ کہتے ہیں کہ بڑے ہمارے معاملات جو ہیں وہ سنے جائیں تو آپ اس وقت تک یہ بات نہیں کہہ سکتے جب تک آپ نے UN چارٹر نہ پڑھا ہو. اگر آپ یہ چاہتے ہیں کہ عالمی عدالت انصاف میں سیاسی مسائل بھی جائیں, اب یہ ایک سیاسی آواز تو ہو سکتی ہے, لیکن جب تک آپ قانونی طور پر ان چیزوں کا مطالعہ نہ کر لیں اس وقت تک آپ اس نتیجے پر نہیں پہنچ سکتے کہ کیا یہ ہو سکتا ہے کہ نہیں. تو آپ اٹلانٹکا کیس لے کے گئے, پاکستان گیا, مگر ایک ٹیکنیکلٹی کی بنیاد پر وہ کیس نہیں چل سکا بیکاز وہ وہاں پر فائل ہونا مشکل تھا. سو اس طرح سے جو ادارے ہیں ان کو سمجھنے کے لیے, ان کی فنکشننگ کو انڈرسٹینڈ کرنے کے لیے جو لا ان کو کریٹ کرتا ہے اس کو سمجھنا بے حد ضروری ہے. اسی کانٹیکس میں وی ول ناؤ اسٹارٹ ڈسکشن ود ریفرنس ٹو the United Nations Charter, and we will see how does this charter provide a skeleton of functioning, and how does this small charter of about 100 odd provisions creates an organization which has stood the test of time, which has stood the political turmoil, which has stood the political pressures, and has survived as a very unique venue for the states on both the developing sides and the developed sides. Let me take you through the provisions of the charter in some sense. ظاہر ہے کہ ہر آرگنائزیشن, اور اسی چارٹر کو ہم بطور ماڈل کے طور پہ یوز کریں گے ٹو ڈسکس کہ انٹرنیشنل آرگنائزیشن جو ہیں وہ کیسے فنکشن کرتی ہیں اور ان کا فریم ورک جو ہے وہ کیا ہوتا ہے. ہر چارٹر یا ہر ادارہ جب قائم ہوتا ہے کسی ملٹی لیٹرل ٹریٹی کے تھرو, تو اس ادارے کا ایک ٹریٹی یا ریزولوشن ہوتا ہے, اور اس ریزولوشن کا پہلا حصہ ہے آبجیکٹس اینڈ پرپزز, کہ اس کا مقصد کیا ہے, یہ کیوں وجود میں لایا جا رہا ہے, یہ کیا کرے گا. تو ایک سمری ہوتی ہے آف دا ویژن آف دیٹ آرگنائزیشن, اور وہ سمری ہم UN چارٹر کی اوپننگ میں دیکھتے ہیں جو کہتا ہے کہ ٹو ری افرم ٹو ہیو ٹو سیو سکسیڈنگ جنریشنز فرام دا اسکورچ آف وار which twice in our lifetime has brought untold sorrow to mankind, and to reaffirm faith in fundamental human rights, in the dignity and worth of the human person, in the equal rights of men and women and of nations large and small. So یہ پہلے وار کو روکنا, اور اس کے بعد fundamental human rights, dignity of human persons, equality of men and women and of nations large and small, یعنی کہ قانون کی نظر میں جو نیشنز چھوٹی ہیں ان کا بھی ایک ووٹ ہے UN جنرل اسمبلی میں, جو نیشنز بڑی ہیں ان کا بھی ایک ہی ووٹ ہے UN جنرل اسمبلی میں. ٹو اسٹیبلش کنڈیشنز انڈر وچ جسٹس اینڈ ریسپیکٹ فار دی آبلیگیشنز arising from treaties and other sources of international law can be maintained, and to promote social progress and better standards of life and larger freedom. And for these ends, اب ان مقاصد کے لیے, to practice tolerance and live together in peace with one another as good neighbors. اور اس کے بعد پھر وہ آگے کہتی ہوئی hereby establish an international organization to be known as the United Nations. اب اس کے بعد جو پہلا چیپٹر ہے وہ purposes اور principles کی بابت ہے. سو آرٹیکل 1 پرپز بیان کرتا ہے, آرٹیکل 2 جو ہے اس کے پرنسپلس کی وضاحت کرتا ہے, اور اس کی سمری جو ہے وہ میں نے آپ کو پڑھ کے سنا دی. ٹو مینٹین انٹرنیشنل پیس اینڈ سیکورٹی, ان الفاظ کا استعمال بار بار UN چارٹر میں نظر آئے گا. اور اس کا آرٹیکل 2 جو ہے وہ بہت امپورٹنٹ ہے, بیکاز آرٹیکل 2 جو ہے وہ سبسٹینٹیو لا کریٹ کرتا ہے. آرٹیکل 2 کا سب آرٹیکل 4 دنیا کی تاریخ میں یہ کہا جائے کہ سب سے اہم قانون کریٹ کرتا ہے تو غلط نہ ہوگا. آرٹیکل 2(4) of the UN Charter creates perhaps one of the most significant international law principles of all times. And it's a big statement I'm making. But look what it has and what does it translate into. Now it's a substantive provision. All members shall refrain in their international relations from threat or use of force against the territorial integrity or political independence of any state or in any other manner inconsistent with the purpose of the United Nations. یعنی تمام ممبرس کو ممنوع کر دیا گیا وہ کسی ملک کی ٹیریٹوریل انٹیگریٹی اور پولیٹیکل انڈیپینڈنس کے خلاف طاقت کا استعمال نہیں کریں گے. اس کا ایفیکٹ یہ ہوا کہ اب آپ کسی ملک کی جگہ پر قبضہ نہیں کر سکتے. UN چارٹر کے آرٹیکل 2(4) سے پہلے आप किसी भी मुल्क पर फौज कशी कर सकते थे, आप किसी भी मुल्क पर अटैक कर सकते थे. You could actually conquer a territory and claim the title of that territory through conquering it. Through conquest was a genuine mode of acquiring and expanding territory of a state. Article 24 eliminates that. So it's a sea change of international law principle that has ever been witnessed in the modern history. And the impact is, as you can see, after 1945, when this charter has seen the light of the day, since then and today, you do not have wars of aggression. You do not have countries attacking another country in order to expand its territory. Not even a single instance. If there are wars, they are because of legal interpretation of a certain treaty. If you want to take over Kashmir, then you have an argument on the basis of that you do not agree that this is part of Indian territory. So you want to resort to measures use of force. You do not agree. But if there is a territory which is completely independent, you will never be able to attain its title or claim its title on the basis of contest. So you make military moves. You go into the territory of another state, but eventually at the time of ceasefire, you withdraw. Despite the fact you take control of the territory for a time being, you make tactical moves, but in a larger strategic perspective, you eventually withdraw to the point where the international position was at the commencement of hostilities. And this is because of Article 24. And this Article 24 thus establishes that international law and its strength is something that you should not lightly dismiss. This law has created a discipline. This law has singularly been a major basis to create world peace. Anyway, coming to our chapter 2. All international organizations talk of memberships. So does this chapter 2. Chapter 2 talk about the membership that all members, talks about original members who've signed the original charter, and then they offer membership to all peace-loving countries. And at that point in time when the charter came into existence, it was not being expected that the charter will have global following. Now it has, and effectively no member state has chosen to stay, no state has chosen to stay out of the UN because of the enormous significance, because of the unique platform it offers to small members, because of the platform to ventilate grievances it offers to the states. No other international body offers such a venue where a powerful state and a weak state sit side by side, debate, discuss, negotiate various international issues and disputes. Then is chapter 3. Chapter 3 talk about organs, but which are the organs of the United Nations? And it provides in formulation exactly what I was trying to explain to you on the chart a little while ago. There are established as the principal organs of United Nations a General Assembly, a Security Council, an Economic and Social Council, a Trusteeship Council, an International Court of Justice, and a Secretariat. So they are the major organs of United Nations. Then it says such subsidiary organs as may be found necessary may be established in accordance with the present charter. So a mandate was given to establish subsidiary bodies, and pursuant to this mandate, several subsidiary bodies have been established. The General Assembly, then chapter 4 talks about the General Assembly. UN General Assembly. It consists of all the members. It will discuss all matters within the scope of the present charter. So its first important mandate is open discussion on all matters that are relevant to the charter. It will discuss or consider principles of cooperation for maintenance of international peace and security. So it will highlight those principles. And it will discuss questions again relating to maintenance of international peace and security. And it may call to the attention of Security Council any matter which is likely to endanger international peace and security. So UN Assembly can pass a resolution directing the UN Security Council to take cognizance of any matter. Article 12 and Article 13 talks about recommendations that the UN General Assembly will give. Again, UN General Assembly mandate is of a recommendatory nature. Resolutions passed by UN General Assembly mostly are not binding in nature. they are widely respected, they are also disregarded, but they represent a unanimity of a legal view, and that is a very important legal value. If a resolution has been passed by UN General Assembly, it represents that majority of 194 states want this issue or believe in this argument or take this legal position. If the resolution is in respect of a legal position, then that resolution becomes an evidence of an evolving custom, because most of the countries have agreed to that legal principle. So UN resolutions passed in General Assembly may not be binding, but they are still extremely valuable based on their legal content, and they can be cited as evidence of various countries' positions. It considers reports from the UN Security Council, and it also supervises trusteeship system. It also approves the budget of the entire United Nations. Each member in General Assembly has one vote. So this parity is amazing, that a country which has population less than a town in US has one vote, and a country like US, which is a complete continent, has one vote. So this equality in UN General Assembly is very redeeming and very satisfying for developing countries, and one notices that they have been making efforts to use this to their advantage, and it also annoyed the great powers in the last few years. In particular, we noticed that there was a serious movement, shall we say, against United Nations, because the developing countries would put together their votes and create annoying positions, notwithstanding and not agreeing to the powerful countries who also had one vote. Then it talks about the contributions, and then we come to chapter 5 of the UN Charter, which is the creation of the UN Security Council, a very important chapter. UN Security Council is to consist of 15 members, and we know the controversial introduction of the veto, whereby you have to have the concurrence of all the 5 permanent veto members before a binding resolution of UNSC could be passed. And there are political background reasoning to that. In any case, that's the legal structuring. It has also been said that UN Security Council has the primary responsibility for international peace and security. And this is Article 24(1), whereby a permanent power of attorney has been given to UN Security Council by its members in the following words. In order to ensure prompt and effective action by UN, its members confer on the Security Council primary responsibility for the maintenance of international peace and security, and agree that in carrying out its duties under this responsibility, the UN acts on their behalf. It is effectively a power of attorney that the member states are granting in the Charter to the UN Security Council, that its members confer on the Security Council primary responsibilities. We give it to you. You are the primary responsible entity within the UN on our behalf. So we confer this on you. ये power of attorney आपने दे दी. And then we also say, agreed in carrying out its duties under this responsibility, the Security Council acts on their behalf. It will act on their behalf. So we also validate that. Then Article 29, which says Security Council may establish such subsidiary organs as it deems necessary for performance of its functions, and these organs are, of course, various committees, various entities, various judicial forums that UN Security Council has been establishing over the years through this mandate. Then we come to Chapter 6. And in Chapter 6, we're talking of pacific settlement of disputes, how disputes will be resolved. The parties to any dispute, the continuation of which is likely to endanger peace and security, shall first of all seek a solution by negotiations, inquiry, mediation, conciliation, arbitration, judicial settlement, resort to regional agencies and agreements or other peaceful means of their own choice. So this is an enlistment of the hierarchy of judicial forums, or resort to various means to resolve a dispute. Article 35 is very important. Article 35 gives a mandate to UN Security Council. Any member of the UN may bring any dispute or any situation of the nature referred to in Article 34 to the attention of Security Council or of General Assembly. Now what happened was, in case of Kashmir, for example, India wrote a letter to UN Security Council pursuant to Article 35 and bringing it to the notice of the UN Security Council. Later, of course, India tried to argue that this was not a dispute between India and Pakistan and that they should not be viewed as an adversary or a party to a dispute, but they should be viewed as a complainant to an aggression by Pakistan. But because of Article 34, which was specifically mentioned by India in their letter to UN, they had this inherent legal disadvantage which referred to dispute. Anyhow, we need not go into that. We have already discussed this article when we had discussed the legal aspects of Kashmir issue. Article 35 in that context is important because we are familiar with this article in the Kashmir perspective. Article 36 talks about that the Security Council may recommend appropriate measures for resolving of an international dispute or diffusing a situation. Article 37, 38 also refer to various actions that can be taken by the United Nations Security Council. Chapter 7 of the UN Charter, however, gives enormous powers to the UN Security Council. Chapter 6 talks about measures which have a recommendatory nature. The UN Security Council can recommend certain measures. Chapter 7 says the UN Security Council shall determine the existence of any threat to the peace, breach of the peace, or act of aggression, and shall make recommendations to maintain or restore international peace and security. The first, UN Security Council has to determine that a situation exists of any threat to peace or breach of peace. And then it can make recommendations in terms of Article 41, may decide what measures not involving the use of force are to be employed, which is essentially sanctions, sort of force, or some sort of other protesting measures. Article 42 talks about reference to actions such as actions by air, sea, or land effectively authorizing use of force. And Article 43 talks about making available to UN Security Council contingents by various armies of these states so that this contingent could be used as a force of UN, and as and when there is an authorization to use force, this force could be resorted to or utilized. This force never came into existence because the requirement of entering into discussions and entering into specific agreements to place at the disposal of UN contingent of the force could not materialize. But despite that, the UN SC continues to retain enormous powers of significant nature to direct member states to do certain things or to prohibit from doing certain things. Article 51 in this chapter is important again by virtue of its significant contribution to the law of self-defense. It codifies the right of self-defense, that you can use force in cases where one is attacked. I need not go into detail because in the use of force chapter we have discussed this. Chapter 8 authorizes regional arrangements. Article 52 says nothing in the Charter precludes the existence of regional arrangements or agencies for dealing with matters relating to maintenance of international peace and security, provided that such arrangements are consistent with the purpose and principles of the UN. It was an effective authorization that at a regional level organizations could be set up provided their activities are not inconsistent with the Charter principles. Then the next chapter, which is chapter 9, talks about international economic and social cooperation and lists down various measures at what will be the nature of that cooperation, solutions for international economic, social, health and related problems. And then in chapter 10, it effectively establishes the Economic and Social Council. Its composition is provided. And the composition is followed by the concept of jurisdiction and its mandate under the Charter itself. Chapter 11 of the UN Charter deals with the declaration regarding non-self-governing territories, and the following chapter establishes the international trusteeship system. This system is less relevant today because territories which were under trust hardly exist. Therefore, the council which was established pursuant to Chapter 13 is also not active in legalistic sense. Then the next chapter establishes the International Court of Justice, creates a mandate, and then refers to the statute of the International Court of Justice, which is an annex to the UN Charter itself. Chapter 15 talks about the Secretariat and the competence of the Secretariat. And this is interesting because its Article 98 says, the Secretary General shall act in that capacity in all meetings of the General Assembly, of the Security Council, of the Economic and Social Council, of Trusteeship Council, and perform such other functions as are entrusted to him by such organs. The Secretary General shall make an annual report to General Assembly on the work of the Council. So in other words, he provides secretarial support for the functioning of all the organs. Remember, UN Security Council, UN General Assembly meet as the members converge, but there needs to be some secretarial support for those meetings, for those activities, for the decisions which they take, their follow-up. And that secretarial support is provided pursuant to Chapter 15 of the UN Charter, whereby the Secretary General is given this responsibility, and the Secretary General has the mandate to ensure that proper support is extended to all these organizations for their proper and smooth functioning. Article 99 is significant because it says the Secretary General may bring to the attention of the Security Council any matter which, in his opinion, may threaten the maintenance of international peace and security. Now here the Secretary General has been given some important powers, and those powers are confined to the fact that he may bring to the Security Council such matter which is likely to endanger international peace and security. So he has a reporting obligation. He has an obligation to bring to notice of Security Council. Of course, Security Council is not dependent on this bringing to attention mandate of the UN Secretary General, but it nevertheless is an additional mandate that maybe Security Council may have missed some event, some happening, some developments that are likely to endanger peace and security. So UN Secretary General has been given that mandate to point out that development. And as I read Article 98, the Secretary General shall discharge such functions as are entrusted to it by these organs. What does this mean? This means that UN Security Council or UN General Assembly passes a resolution. In that resolution, they create a certain task for the UN Secretary General. So UN Secretary General has to perform that task. Sometimes if you read carefully towards the end of the resolutions, they say the Security Council shall remain seized of the matter, and the Secretary General shall be asked to report developments in this regard. And then when it is so said, then the Secretary General has an obligation to report such developments. For example, in the UN Security Council Resolution 1172 passed in 1998, almost this kind of mandate was provided for. And the mandate was that the Security Council shall remain seized of the matter, and UN Secretary General shall report back to the Council developments that India and Pakistan are taking with reference to having a dialogue on all issues relating to disputes between them. So after that resolution, the UN Secretary General has been periodically issuing various press statements welcoming India and Pakistani leaders coming together, having a dialogue, having discussions wherever those discussions were held, wherever those dialogues were held. There has been a follow-up by the UN Secretary General office, whereby the UN Secretary General has been issuing statements. These statements are issued not as a matter of mere diplomatic courtesy, but as a matter of discharge of legal mandate under Article 98 and 99 of the UN Charter itself. So one notices that the international bodies, UN-related bodies, are functioning within the framework of law. They are functioning within the framework defined by law. This law is written in their treaties. This law is written in the instruments which create them. And that is all the more reason why one needs to understand this law, why one needs to read these statutes, these conventions, these treaties which establish these UN bodies and UN organs. And in an example that we have gone through of the UN Charter itself, we have had a good look that it controls all aspects of membership, qualification, participation, voting rights, issues relating to specialized bodies within the setup, issues of conferring powers to these bodies to permanently exercise those powers as and when required, issues relating to conferring jurisdiction on various bodies within the same setup, issues of raising questions before these bodies, the secretarial support to these bodies, the equality of members, the functions, the jurisdiction of these powers, and so on and so forth. All these issues that one would like to politically take up are provided for in the legal language of these treaties. So before you want to know anything about an international organization, before you want to study about an international organization, its effectiveness, its ability to deliver, first thing that you must do is to start with the constituent instrument. Start with an instrument which creates that body and read it, and then see what kind of jurisdiction is conferred on this body and how that jurisdiction has to be exercised. Because every state has its own interest with reference to that international organization. Every state has its own interest with reference to the UN Charter. But that interest cannot be served. That national strategy cannot move forward unless there is a very clear understanding of the law involved in the creation of that organization. So once that organizations and its associated laws are understood, one becomes very comfortable in devising, in creating national positions, in knowing what it can do and what it can't do. So it becomes an occasion to self-discipline the expectations that a state may have. Some of these expectations may be completely irrelevant. Some of these expectations may not be achievable. Some may actually be achievable. Some may be achievable if put differently. The answers to all these will become available only if you are able to understand the law applicable to these international organizations, and the law is found in the instruments which create these bodies. I hope I have been able to clarify for your understanding and for your comfort the law regulating United Nations, its associated bodies, and how this law can be put to advantage. And with this, we come to an end of our lecture, and I hope this lecture has been able to make clear to you another aspect of international law, law relating to the UN bodies, law relating to the UN Charter, and hopefully you would be now better positioned to understand the functioning of these bodies and assess how best national interest could be served in them. Thank you very much.